चलिए मेरे साथ आइए और बेधड़क होके बातें करते हैं।
Now I come to the legal part of the Patanjali advertising case. The Indian Medical Association, not surprisingly, is the petitioner in this case. The respondents in this case are the Government of India, the Government of Uttarakhand, and Patanjali. What's the case about? The case is that Patanjali was advertising or misadvertising a permanent cure to diseases like diabetes, cardio ailments, cancer, and degrading health. That was under the Magic Remedies Act 1953, which has a list of diseases to which you can never claim permanent cure. If that indeed is the act, and so it is, then what about the statements made by doctors and hospitals that they can reverse diseases? They can, you can do a bypass and your heart problem is solved, and then you do a lung transplant, your lung problem is solved, so on and so forth. They come under the same category. The charge of the petitioner was that the government of Bharat was not taking action against Patanjali. It appears that the Advertising Council, ASCI, had also issued notices to Patanjali. That leads me to think, what about Complan Boy? What about Boost is the secret of my energy? What about Woman Horlicks? What about Safola? These also advertise disorders or diseases that can perhaps be never cured. And what is there to say that you drink Complan and you grow some few inches taller? These need to be examined too. What about the trips sponsored by the pharma industries of the doctors to places like Bangkok and Seychelles and Maldives, etc.? What about the incentives given to the medical representatives, and how do they go and where do they go? Do we know that 40% of the digital advertising by the Bharat's pharma market is actually push advertising? Meaning you don't have to do anything. The advertisement just pops at you when you open your laptop. The Supreme Court had issued an order to Patanjali not to advertise after this case came up further. But Patanjali went and re advertised, and that is when there was a contempt of the court. When the petition came up to the hearing of Justice Hema Kohli and Justice Amanullah, the Justice Amanullah said, "We will rip you apart." The retired Supreme Court judges said this was not a good behavior. This lowered the dignity of the office. It resulted in a contempt petition against the judges themselves with National Human Rights Council. There have been past precedents where judges have been penalized. Then Patanjali went and tendered an apology. And then the honorable judges said that the size of the apology should be the same as the advertisement. I ask, A, the apology has been tendered not once but at least twice. Then now we hear that the size of the apology has got to be the same size as the advertisement. Is that not an overreach? We see thousands of corrigendum ads throughout the day, every day. Does it mean that all corrigendum ads are of the same size as the original ad? Is it not an overreach? My lord, there are hundreds of important things to do. Is the size of the advertisement so important? Because if that were to be, it would create a situation where one could say that there is a bias for the Indian system of medicine, or rather, against the Indian system of medicine. Therefore, I urge the honorable judges not to look at the size of the advertisement.